What's your reaction to the ruling?
It would be an understatement to say that it's significant. It is huge, it's historic, and it is a further fulfillment of the great promise of our Constitution and of our democracy. Basic concepts of equal protection under the law, due process, respect, dignity, validation for every human life. It's in our Pledge of Allegiance with liberty and justice for all. It's in every aspect of the American government and its structure and foundation. So this is a day to rejoice, and every American should be feeling this way. This is a victory for everyone. The oppositional voice has always been confounding to me, because how does providing more liberty, more access to justice hurt anybody? And so yes, we can be of different opinions, we can be of different religious beliefs, and of course even among faith leaders there are those in support of equal marriage rights, those who are opposed. But this is a democracy, and our holy books are not any one interpretation of any one particular holy book. Our holy books are the Declaration of Independence, the Bill of Rights, and the Constitution of the United States. That's how we make the decisions that rule our land. For years, even before I became an elected official, I'd been involved with the issue of equal marriage rights. It was the Supreme Court of the state of Hawaii way back in the early 1990s. So this has hardly been a new subject or a rushed idea. This is going back nearly 25 years, when the first United States State Supreme Court ruled that it was unconstitutional to deny loving and committed same-sex couples a marriage license. So I got involved around that time, but then once I was in elected office, I was forever moved by the November 2003 decision of the Massachusetts Supreme Judicial Court, which ruled, not unlike the Hawaii and Vermont courts by that time, that there was no constitutional basis for this discrimination. Number two, that our nation's history had taught us that separate is seldom, if ever, equal. But then the Massachusetts High Court went on to say something that has stayed with me and will forever. They said that the only remedy to this identified discrimination is marriage and marriage alone, that no parallel construct such as civil unions or domestic partnerships would do, they said, because it would, in the words of the Massachusetts High Court, perpetuate a destructive stereotype that suggests there's something inferior and unstable about the way same-sex couples love. And I'd never thought about it like that, because if we're going to have our government tell us that some of us love good enough, and we're going to give those people marriage licenses, and these other people, well, maybe they love, but not good enough, and we're going to give them civil unions or domestic partnerships, that you can discredit and disparage an entire class of Americans by having the government tell you who loves good enough. I mean, this is just the furthest thing of what government should be talking about. And I challenge anyone from the left to the far right to disagree with me on that. And I thought at that point, I was ready to fight a war over a word, because I wasn't going to have my government tell me that I don't love equal to my neighbor. So it was at that point that, working with the sponsor of our bill, Equality California, that we decided we would introduce an equal marriage rights bill in the early part of 2004. And we determined that we would do it on Valentine's Day weekend, which is a point in the calendar where advocates for equal marriage rights for many years had been going to their county clerks, same-sex couples, requesting marriage licenses, knowing they would be turned away, but just to make the protest and to make the case for equal marriage rights. What I didn't know was that my mayor in San Francisco that same week, Gavin Newsom, was considering whether he was going to determine himself that the current state law was unconstitutional, which in 2008, the California Supreme Court finally did make that determination, and that he would direct his county clerk in San Francisco to begin issuing those marriage licenses. So that was February 12th, 2004, the same day that I introduced the first of its kind, both in California and in the nation, an equal marriage rights bill here in California. So we moved it forward. 2004, we didn't have the votes to take it to the floor. So it was historic, just every step that we took. Got it passed out of the Judiciary Committee, and then it went on to the Appropriations Committee, where I personally held it, but with the promise that we would be back after the November 2004 elections and reintroduce a new marriage equality bill in December of 2004 and move it in 2005 with the express intent to get it to the governor's desk. And in fact, we did that. First state in the country. We beat New York State by 6 years. Of course, their governor had been a great proponent, and he challenged the legislature in the state of New York in 2011 to put an equal marriage rights bill on his desk, which they did, and he signed. But here in California, we didn't have a governor who could see the future or had it in his heart that we should treat all people equally under the law. You know, the Equal Protection Clause of the California Constitution, and I'm not a lawyer, so life is much easier and simpler for me, but tell me what I'm missing. Our state constitution's Equal Protection Clause says, no citizen or class of citizens shall be provided any privilege or immunity not provided to all citizens on the same terms. So we're going to provide marriage licenses for you citizens. Well, then we have to provide them to all citizens on the same terms. And finally, we're getting there, but unfortunately Arnold Schwarzenegger could not see that simplicity of the state constitution. And so he vetoed our bill in 2005. We reintroduced it in the 2007 session, again, after the elections of 2006. And in November of 2006, we dispelled a great myth, because up until then, it had been thought and considered that to support equal marriage rights was a political, explosive, damaging thing to do for a candidate. But in fact, in Democratic primaries, those Democrats that supported equal marriage rights defeated candidates who did not support it. And so we elected even more legislators in 2006 in support of equal marriage rights. And when we reintroduced the bill and placed it on Arnold Schwarzenegger's desk a second time in November of 2000, in the summer of 2007, we had even more votes for it. So support was only rising, and unfortunately, he still couldn't see the future, and he vetoed it a second time. And I just want to talk briefly as to how his signature could have changed the course of history. If he had signed that bill either in 2005 or 2007, I'm quite certain that our adversaries would have, not unlike they did in the summer of 2008, following the June 2008 decision by the California Supreme Court, that Prop 22, which limited the definition of marriage in California to between a man and a woman, would have gathered the signatures to try through the referendum process to overturn the new equal marriage rights statute that would have been created with Arnold Schwarzenegger's signature. But we would have gone to the ballot with the Republican governor leading the charge. And he, like any governor, would have done everything in his power to fight to have his signature sustained by the voters. And I think that kind of leadership, in particular from a Republican governor, could have literally changed the course of history. And Prop 8 never would have happened. All of these years of court challenges would have taken a completely different course. But if it's not how it unfolded. It's unfolded in its own time and its own way. And the good news is, of course, that we now see that having reached the Supreme Court of the United States and over this course of years, seen popular support grow at exponential rates and accelerated in a way we've rarely seen, if ever, in a social movement in this country or anywhere else. You know, when Prop 22 passed in March of 2000 by a figure of 61 to 39, and the words of Prop 22, the same words of Prop 8, 8 years later, though Prop 22 put these words into the California Family Code, Prop 8 placed those words into the California Constitution. Only marriage between a man and a woman will be valid and recognized in California. That 61 to 39 in 2000, well, today, not just here in California, but at the federal level, there are about 61% of Americans who support equal marriage rights, and maybe 39% opposing. So we've seen it completely flip in just a matter of, well, now it's 15 years since the passage of Prop 22. By 2008, we had seen that 22-point spread reduced to 4 points because Prop 8, the same words placed in the Constitution, passed by 52 to 48 margin. So they went from a 22-point advantage to a 4-point advantage in those 8 years, and now we've seen it take off even further. Traditionally, the U.S. Supreme Court does not lead on social issues. They follow the public. And I'm always reminded of President Abraham Lincoln's comment that with public sentiment, nothing can fail, and without it, nothing can succeed. And of course, we know the context in which he said those words. And the context is not that different from today. Respecting, dignifying, validating every human life in our democracy. There are great disparities in income for the LGBT community compared to the general population. We have higher rates of suicide because young people are still suffering abuse, emotional, physical, and sexual in their own homes, oftentimes leading to their running away. We have higher rates of homelessness in San Francisco. About a third of our homeless population identifies as lesbian, gay, bisexual, or transgender. Rates of suicide higher than the general population. All of this as a result of continued levels of discrimination. So we change attitudes, we change hearts, we change minds, we change laws. Brings people along, makes things better for any particular community. But that doesn't mean the work's over. There's a lot left to do.